This is our first Bay Area Housing Market Town Hall webinar in 2023. So as you see that, we're gonna start with a housing market update from 4 to about 4:25 p.m. And then we're gonna invite Daniel Bornstein to come and join us and start sharing with us about the 2023 legal landscape for residential landlords. Now, to start off with, reminding everybody to subscribe on our YouTube channels if you want to get updated on the recordings and also past recordings for our episodes. We did quite a few since 2020 March. So today is our 38th episode. We have tons of information, and especially if you're interested in commercial real estate, for example, multifamily, we do have some workshops that we have on the YouTube channel as well. Recently, if you have seen some of the postings I put on Facebook Bay Area Housing Market page, for example, in Fairfax, they are implementing new rent control law and just cause eviction. Right now, for example, a homeowner who has an ADU behind their house, now she said, I don't want to rent anymore because now I'm scared to rent out my unit. What if I cannot get rid of the tenant if the tenant is bad? And Alameda County now become the first in the US to restrict landlords' use of background checks. I actually talked to some property managers. Some property managers haven't even heard about this. And today, Bloomberg has an article that says the White House is considering broad actions to expand tenant protections. What kind of tenant protections? So this is something that I think is really worth our time to see. So that's why I asked Daniel to come on here, especially he was also being interviewed by ABC7 to talk about the Alameda County starting to become the first county to restrict landlords' use of background checks.
So a little bit about myself. For those of you who don't know me, I'm Daniel Bornstein. I'm a attorney. I've been practicing law for over 25 years. My core focus has been representing property owners, brokers, real estate investors, property management companies, and trying to resolve landlord-tenant disputes. And having done this for 25 years, I can only tell you that it gets harder and harder and more difficult each year as the regulations continue to pile up upon ourselves. And what was 25 years ago, a Bay Area jurisdiction where we had Berkeley rent control, San Francisco rent control, Oakland rent control. Now we have a patchwork of rent control throughout the Bay Area. So it becomes even more cumbersome and complicated to talk about generalities until we actually know what jurisdiction we're in. And then to add insult to injury, if you're not subject to a local just cause rent regulation environment, you are going to be subject to state rent control and state just cause eviction. So I can only tell you that it's particularly complicated. And in some respects, you need to have an attorney involved in decision making when making a decision about purchasing a multi-unit property, so you have a working knowledge of what the ordinance and what the rules are for that property. So with that introduction, I am happy to help out, happy to answer questions. What I'd like to do is go through some slides about some new information that will help clarify matters, and then at the end I'll take some questions. I do want to say this, that homeless dynamic that you have referenced, it's a very, very tricky issue. Mm-hmm. And what I tend to say generally, because I don't want to walk into a political hot potato button, is simply we need to build more housing. If you build more housing, you will have more housing, which will mean that more housing will be available for a larger population that will be more economically diverse. And even if you build high quality housing that's expensive, those other properties that are older and are less aesthetically attractive will be lower in rent for other people to access. So we've got to commit to building more and more housing and reduce the regulations, the permit time, and what have you, so that we can focus on building and doing so efficiently. So with that, I'll leave that and I'll ask you to change the slide.
Well, I want to say that thank you for saying that, because for I don't know how many episodes I've been talking about this. At the end of the day, this is just my personal opinion, is that I do agree with you. If they increase the supply of housing, if we can have less red tape in terms of like building, then we can increase more of the housing supplies and make it little bit more affordable for people.
That is the hope. And the only thing is it requires a lot of resources and the political will
Yeah,
of our community to start building. And that has been a consistent inherent problem throughout our community at this point.
exactly. Exactly. All right. I'm going to go ahead and let you start. Here, go.
Sure. So I wanted to mention in San Francisco, and usually San Francisco is got different rules and regulations that tend to be as pernicious and difficult as any jurisdiction throughout the country. And even though many of you will know that the statewide eviction ban expired, San Francisco, once that ban expired, implemented a rule that as of July 1st, 2022, if you don't pay your rent, a landlord can proceed with serving a 3-day notice to pay rent or quit. And if you continue not to pay your rent, you can face a lawsuit seeking your removal from the premises, but you still have the ability to assert a COVID financial impact as a defense to that lawsuit. And so even though the gates have opened for pursuing lawsuits for non-payment of rent in San Francisco, we're still confronted with the fact that the COVID defense of impact on my financial health is still a viable defense in San Francisco, which means tread carefully, contact an attorney so you understand what you're up against, because even though you may walk around saying the eviction ban is over, you've got to know what the rules are in each and every particular jurisdiction. Another note, San Francisco has added a warning requirement for those nuisances and lease breaches that are not reflective of an imminent risk of public safety or health. So normally we used to be able to serve a 3-day notice to cure or quit for a violation of a lease covenant. Now we first have to send a 10-day warning before we can have the right to pursue the standard 3-day notice in San Francisco. What this means is that there's more regulation, more bureaucracy, better for the attorneys because there's more work for me. But in the end, what it does is cost you more to recover possession of a unit where you have someone who's not behaving properly as a community member, whether it's excessive noise, whether it's bringing a deluge of pets that don't have permission to be on the premises, whether it's partying, vandalism, graffiti, drug use. All of this is slowed up because of the rules and regulations that are in place in San Francisco. It's very frustrating. And all I can say is that if you own property in San Francisco, a multi-unit property, a single family home, you do need to have an attorney before you proceed with a dispute, because you don't know what you don't know. And that's what gets you in trouble in real estate. Another point is San Francisco is regulating short-term rentals, and there is a rule about only offering 12-month leases. So if you're advertising a multi-unit property for rent, you can only offer it as a 12-month lease, no short-term rentals. There are ways around this, but you have to offer it as a 12-month lease. There are nuances and caveats. And what I like to do is give you the major rule and then let you ask me questions later on an individual basis on a particular situation. If you want to rent a place out for less than 12 months, you rent it for 12 months, but offer in the body of the lease agreement an escape clause that allows for a tenant to exit the lease upon 30 days notice. That's how you can get around the law. But what happened was there was a proliferation of short-term rentals throughout San Francisco, corporate rentals, and the politicians frowned upon that because they felt like it was losing housing stock for traditional renters and driving up prices. So they made a rule that now you have to offer leases at no shorter than 12 months, unless you have permission to do so otherwise. Let's move on. Statewide, there's been repeated chatter about a rent registry, a statewide rent registry where you would have to divulge information about your private real estate holdings on a inventory list that would provide information about square footage, amenities, rents, and what have you. Many people find that to be invasive of their personal financial information. However, San Francisco and Oakland have established inventory programs where you must disclose information about your property holdings, and this information is available. And San Francisco has had it in place since July of 2022, and now commencing March of 2023, if you own less than 10 units, you're now required to report as well. Oakland has followed the same approach. And the only thing I can tell you is that this disclosure of information is unordinary anywhere else in the country, but for these places that are heavily regulated. And remember, housing is very political. And the idea of having a government accessing your information for purposes of scrutiny is something that, in retrospect, many people find it unreasonably invasive, as do I. I just want you to know that regardless of whether I find it invasive, fair, you still got to comply with the law. And if you don't comply with the law, there are repercussions that can harm you. Recently in Oakland, we had a vote that enlarged just cause eviction protections to more housing stock in Oakland. And I bring this up because I want you to understand there's a continuation of a march to over-regulation of rental property. And just like Helen broached that nice slide about the White House maybe considering additional tenant protections, it's starting to look like to me that housing is going to be treated like utilities, and especially regulated like electricity, gas, and water, and that what we traditionally thought of as private property, the enlargement of government regulations, inventory lists, or regulations about just cause evictions starts to look like, well, you may own it, but you don't control it in the way that you contemplated it. And the emergence of landlord-tenant laws and rent control, just cause eviction rules, and reporting requirements are that march to over-regulation. On one hand, you will have tenants articulating that they believe that that is fair in order to ensure that there is no malfeasant behavior by landlords because of the power that housing providers may have over others. On the other hand, there are people saying, look, I just bought a house 20 years ago to help me with my retirement, and I don't want to be involved in this industry anymore because of the regulations involved. It's too tricky, it's too burdensome, too stressful, and too costly for me to effectively manage. And therein lies the just competing narratives. And that's what law is. It's about competing narratives. Public policy is about competing narratives. And my job is just to articulate the tension. And then you have to decide politically where you are on it. And if you're in the industry, you've got to be familiar with the rules so that you can maximize value out of your investments and keep yourself out of trouble. Point. We used to, in Oakland, be able to terminate a tenancy where a tenant refused to sign a lease, the identical lease for a like kind period. Recently, Measure V eliminated this. And so what we have is the inability to terminate tenancies where a tenant refuses to exercise a lease for a like time period. Very, very burdensome. And all I can tell you is if you're deciding to invest in San Francisco or in Oakland, you've got to at least get yourself involved in knowledge acquisition and know that there are times where you need to reach out to an attorney who's conversant in this in order to be understanding and properly consulted about what you can do and what you can't do. A word of caution. We all have computers and can access the internet. You as a savvy real estate agent does a Google search and finds out about Nolo Press or online leases. You've got to be careful. This area of law is so niche specific. If you buy a niche or if you buy a generic lease for 20 bucks off the internet that looks interesting to you, you may make a mistake because you want a idiosyncratic lease for that jurisdiction. And that's how technical it's getting. I want a San Francisco lease for San Francisco properties. I want an Oakland lease for Oakland properties. And an Oakland lease may not be adept and appropriate for a San Francisco property because of the nuances of the ordinance. I'm happy to be consulted at any point in time for my preference in terms of what leases to use.
Daniel, would it be okay if somebody wanted to ask a question?
Sure.
All right. Somebody had asked, what do property owners in San Francisco with less than 10 units need to do to comply with the new registry reporting requirements in March? Example, will we need to initiate something on our own, or will the city be proactively sending forms for us to fill? And do you know if it will be on paper, by mail, or online?
My suggestion is to Google San Francisco Rent Stabilization Board. Go to the Rent Board's website, and they have a litany of information there about the registry, and that would be the best location for you to learn about the rules.
Thank you.
Interestingly, the San Francisco Rent Board website, which has been retooled, is a very good learning site for those of you who are considering purchasing property in San Francisco. I always tell my clients and prospective clients, look, the first thing I would do is read a good lease agreement. Get yourself comfortable and learn all the issues that are raised in a lease agreement, because it gives you a window into what are the disputes that typically arise. And then you go to the local rent ordinance and read the rent ordinance and all of that information. And I will tell you that that's how you get educated. And so I would recommend that in Oakland, you go to the Oakland Rent Board website. In Berkeley, you go to the Berkeley Rent Board website. In San Francisco, you go to the San Francisco Rent Board website. In Hayward, you've got to go to Hayward and review Hayward. And it got to the point where it's so balkanized with different regions. Emeryville has an ordinance. You've got to know Richmond's ordinance. And it's gotten so niche specific, there are attorneys who will not work in a Bay Area jurisdiction because they simply do not do that work all the time.
I remember we had this conversation before. It's like, even when you're looking for an attorney, you need to find somebody who is familiar with those jurisdiction for that specific city, because it's just very different from city to city. And there are just so many of them.
And your templated notices will not be effective in different jurisdictions. And within that jurisdiction, a tenant will likely get a nonprofit housing attorney who knows that jurisdiction, will look at the notice and simply say, well, obviously this notice is not effective for this jurisdiction. So you have to be very careful. Why don't we change the slide for a moment? And it sort of continues, which is, I've told you there's a march to further regulation. Housing is politicized, and what we have in Antioch, which is pretty far out from the Bay Area, within the Bay Area, is a march towards rent stabilization, and this is something as a result of the tension that is arising throughout communities involving the cost of housing. And so, effective as of November of 2022. We have new rules in Antioch regarding their own rent stabilization rules. And the general understanding is that where we have a local ordinance that is more stringent than the state ordinance, we follow the local ordinance. And so in Antioch, we are now, if we're involved in rental housing, multi-unit rental housing, we're looking at the Antioch ordinance to know and understand what the rules and regulations are. Interestingly, there is now a rent registry requirement in Antioch. The program has not yet been developed. And I mention Antioch because it's one of the recent ones that just came online for rent control. And what we have is any time that you end up purchasing a property before rent stabilization and just cause eviction emerges, the minute those regulations come into effect, you are regulated. And your lease agreement may not be, your lease may say, hey, I can terminate a tenancy on 30 days notice, but you're under the umbrella of an ordinance that constrains you from doing what you will do. And at least once a month, I get a call from an owner And I say, I'm sorry, you can't terminate the tenancy because you want to sell the property. And the owner says, well, the lease agreement says it's month to month. All I have to do is give 30 days notice. And I have to explain to the person, the lease may say you can serve a termination notice, but you're now in the umbrella of a statute that precludes it. And the person grimaces, gets upset. And I have to just say, look, I'm only the messenger to protect you from making mistakes, because there are a ton of outstanding tenant attorneys who are looking for you to serve an improper notice to wrongfully evict someone so that they can file a lawsuit and recover in excess of 6 figures for your mistake. And those tenant attorneys are sending their kids to private schools off of the mistakes made by landlords and housing providers who behave in good faith, but they don't understand, they don't know what they don't know, and they get themselves in trouble. Because maybe 20 years ago, 30 years ago, you can act and operate in some capacity as a mom and pop operator. Nowadays, it's so regulated that you want to be very careful before you take any step further.
Can I kind of elaborate on this? Is that here is the city of Antioch is before 1995. It applies to rental units before 1995, but in the statewide restrictions, that's is 15 years, correct?
Correct.
And so that means from 1995 to 2007, as of today, those properties will not be in Antioch, will not be subject to the rent control.
But they could be subject if they're over 15 years, they segue into state rent control.
Absolutely.
It's
So that
really
will,
tricky. It's like a
yeah.
filtration process. And when people call me, I have to actually go through a whole filtration and question to find out where the property is located, whether it's a single family home, a condominium, or a multi-unit property, when it was built. And then only then can I actually open up the file in my head as to what the regulations are. And if it's new regulations, I got to run to the actual ordinance and review it before I can give advice. 25 years ago, Oakland, Berkeley, San Francisco, easy. Now, very cumbersome. And remember, if you've got a building that's over 15 years old and you're in Walnut Creek may not have a local ordinance, but it's subject to state just cause eviction and state regulation.
Absolutely.
So let's turn the slide. And as I quickly mentioned, more and more suburban areas that are traditionally not associated with tenant activism are becoming active in asserting tenants' rights. It's really a reflection of, as you have a larger population of renting, you're going to have more advocacy. And a place like Antioch, which went through a terrifically difficult foreclosure crisis, you have a lot of people who lost homes who are now living in homes with rental. They're tenants instead of homeowners. And there's where you have political activism for good or for bad, depending upon your evaluation of the issue. What I want you to know is where we have state just cause evictions, we have less regulation than local. So all things being equal, I'd much prefer to be subject to state just cause termination than local ordinances involving just cause evictions. For example, if I'm in Walnut Creek and I want to do an owner move-in in a multi-unit property where an owner wants to move into one of the units, I can do so. And what I must compensate the tenant is the equivalent of 1 month's rent to transition the tenant out of the premises. That's the cost. In San Francisco, if I want to do an owner move-in eviction, it's $7,400 per each authorized occupant, up to $21,000. And if there's someone who's 60 or a family with children, you've got another $4,500. So things can be like $33,000, $34,000 for relocation payments. And so I give you this example because all things being equal, I'd much prefer to be in places that are subject to state rent control and state just cause eviction than local. For example, rent control in state rent regulated buildings, a multi-unit building in Walnut Creek, you still are subject to limitations on rent increases, but they're up to 10%. So a 10% increase on a yearly basis is not a terribly discomforting rent increase. But what you'll see in other jurisdictions is it can be even smaller because it's tied to the consumer price index. All I can tell you is that we really, if you're deciding to terminate a tenancy, if you're buying a multi-unit property, you've got to know what jurisdiction you're in, what rules you're subject to, because it will have an impact on the value of the building. So just like you do your math on cap rates, gross rent multipliers, and you look at what rents are possible, you also need to know, can I displace people in order to recover possession, to renovate a property and then upgrade the unit? It's not that easy. And if you lack that knowledge, you're coming to a decision about an investment without the full understanding and education that the best investors have. I don't expect anybody to have a monopoly on this information. What you have to know is that you have resources that you can go to quickly look at a property, talk it through with an attorney, and help understand what you can and can't do before you act. And that's even when you're in escrow, because I'm a real estate investor. I'm a broker. I have a property management company. I can look at a property in multiple different ways, including what are the regulations that are contained in that jurisdiction that may impact valuation. It also gives you a strategic advantage because, for example, in Walnut Creek, if I buy a tired building with tenants in the building and the building is in a great location, but it needs to be renovated and rehabbed, state just cause eviction law allows me to go and look at the building. It may be selling for less than it's worth because there's long-term tenants in it, but I'm able to, with the right attorney, pull permits to do a substantial rehab, terminate tenancies, provide each tenancy 1 month's equivalent rent, clear out the units, renovate, rehab, and then rent at market rate. You don't have to offer the tenants you displaced in the state just cause eviction rules the place back after the renovation. In San Francisco, Berkeley, Oakland, and those other places, if you're doing a capital improvement that's going to terminate a tenancy, they have the right to reoccupy at the old rent amount until you petition the rent board for more money. So I give you this example because I want you to understand that a savvy investor, knowing these rules, working with an attorney like myself, will be able to see opportunities where others don't. So it cuts both ways. Regulations create an impact on the value of the property, and they also create opportunities for people who understand the nuances and can arbitrage that knowledge to make good decisions about an investment.
I don't mean to be controversial here, but then the cities that you had mentioned with like really tough rent controls are the cities that we've been talking about with really, really high homelessness over there, even with such strict rent control. And then and I would say that even though some people might say that, oh, well, that's what we were trying to avoid, these investors to come in here to buy up these property and then kick tenants out and rent it out as market rate. But at the same time, honestly, I think most of the investors that I know, they are not here to try to rip anybody off. If they have a good tenants, they would much rather to keep the good tenants and then not increasing the rental rate high. They really want tenants who can take care of their property so that they encourage them to invest more and provide more housing.
Correct. And on top of it, if you have a tired building that's deteriorating, there's a value add to upgrading it. You get more rent for it. The city gets more taxes out of it. And we have a better community that's performing nicer because we don't have blight. What rent control often does, which people don't realize, is that there's less circulation of available units because people cleave to the units, which means the price of entry on a vacant unit is proportionally higher than it would be if there was more fluidity in the market. So for those tenants who want to come to San Francisco, who love the idea of San Francisco, they pay an enormous cost to get that vacant unit because there's less vacant units available because of rent regulation. And here's the thing is, I have my opinions, Most importantly, when someone hires me, I work diligently to accomplish their goals as long as it's proper and ethical. And my job is to provide information about regulations and do good work on behalf of the people who hire me. And what I can do is educate people about what they can do and what they shouldn't do. And then it's their decision as to whether they want to proceed or not. Let's look at the next slide, because I've mentioned that state rent control gives you up to 10%. If you look at the amounts here, you'll see that these numbers are quite a bit lower, right? And when you're in a situation where you have a long-term tenant who's been there for 15 years and they're already $1,000 below market, right? And then the yearly increase for Oakland is 3%. So they go from $1,000 to $1,030 when the fair market rent for the place is $2,000.
Yep.
And that's where you get sharp practices where people want to recover possession in order to capture the vacancy, because the vacancy has value. And had we not had a regulated environment, you'd have the market handle things and price points would settle down to a point that's more reasonable. Part of what I do is a lot of arbitraging of vacancies. And so when people have a multi-unit property and there's some units that are performing well and some units that are not performing well, of course, the real estate investor who's motivated to actually capture higher rent at a consistent rate and want to have great tenants, they're going to look at those underperforming units and want to make decisions about them. And the only thing is you've got to do it properly, consistent with the law, and not put yourself in a position where you're behaving in contravention, because there are wonderful attorneys who will absolutely police that and you will be sued.
And I know like a lot of these cities, they're based on the CPI, and the CPI has been really high. Then Oakland just last year had changed their rule as well because the CPI was so high, so they changed to the
right. So the
the
CPI was high because of inflation, and they were concerned about that being too aggressive at this point. So they limited and locked down the maximum amount of increases to this 3% figure. Why don't we change the slide? So I talked to you about state rent control, AB 1482. It came into effect in December of 2020, and many people got distracted because of COVID and the pandemic and really didn't understand the implications of state rent control. Remember, if you have a multi-unit building that's over 15 years old, you're going to be subject to just cause eviction rules. You're going to be subject to a rent regulation. You're going to be subject to relocation payments, as I briefly touched upon. Generally speaking, single-family homes and condominium units are exempt from state rent control and state just cause eviction rules. And remember, the tenancy has to be over 12 months before you are triggering these protections, which means if you have a new tenant in a multi-unit building in Walnut Creek, for instance, you may want to provide them, instead of a 12-month lease, an 8-month lease, so you can, one, insulate yourself from immediately locking them into the protections of the ordinance, so you have a chance to season them as quality tenants. Because if after 8 months you found them to be more difficult than you think is reasonable, you can terminate the tenancy because they have not gotten the protections of the ordinance. And those are the nuances that I can discuss with clients, with the public, that many people who don't understand the ordinance don't have that knowledge base. And that's why it's crucial to have an attorney who you work with in order to basically understand what's possible and what's not possible. So let's move on to Alameda County. Alameda County is the most infuriating county throughout California. We have in Alameda County, where I am a citizen of, we have an existing eviction moratorium, which is precluding the demand of unpaid rent. The courts are closed to evictions, except for public safety and health and LSACs. We have done some evictions in Alameda County for those terrible situations of violence, drug dealing, significant vandalism, arson, but everything else like partying at night, subletting is not available, and especially non-payment of rent. So you can have individuals in Alameda County who have not paid rent for 24 months, and there's nothing you can do about it. You can negotiate a voluntary move out, you can't serve a 3-day notice to pay rent or quit. And this moratorium continues and continues. The supervisors have been sued. The ruling was not favorable initially. The litigation continues, and we're hoping sometime in spring they end the moratorium. 60 days after they end the emergency, the moratorium will be over. Until that time, I have tremendous empathy and sensitivity for those clients who are calling me up and saying, my tenant has not paid me for 2 years. They owe me $65,000, and they ask me, what should I do? And I tell them, pray, because I do not have a solution for them.
Oh my
And
goodness.
normally, as a practitioner in this area of law, I usually can see over the horizon of a dispute and steer people a certain way. I have very little options here other than to negotiate a voluntary move out, offer money to have a tenant move out so you can get a better tenant to start paying. But there are tenants who have not paid rent for many, many months. The debts are enormous. And pre-COVID, I would never have people calling me with a $40,000, $50,000 unpaid residential rental tenant. Now it's in that number because the moratorium precludes serving a 3-day notice to pay rent or quit. The courts are closed to this. And so all we have is an accumulation of rent debt that can't be recovered at this juncture.
That's
The tenant owes the
really-
money, but you cannot demand it and you cannot seek to recover possession of the unit. Alameda County is the only county I'm aware of right now in the state of California that still has existing its moratorium. Los Angeles was the county that was the last one that ended its moratorium.
And that answers Celine. Celine had asked this question. She's a multifamily broker in Walnut Creek, and she asked in Oakland, how do you get around the eviction moratorium? When do you expect the eviction moratorium to be lifted? And you had answered those questions.
Yeah, my hope is it is lifted in the springtime, and then finally by the summer we're starting to open up again. But I mean, the crisis, I'm fearful of the amount of work I'm going to have in my office of all this pent up people wanting to demand rents. And, you know, the game plan is not clear and the courts are already clogged up because of the inertia of COVID and the difficulty of proceeding in the court. So we shall see, but it's a bit of a mess and work in progress. Let's move on. We do have some new laws that came into effect that I want to briefly touch upon. There's a wage garnishment limitation where you can't garnish wages against certain debtors in certain situations. Greater protection for victims of domestic violence who live in rental housing. They're able to protect themselves from the litigation that typically arises when we have violence inside a unit. They can end a lease and have fewer repercussions as a result of ending a lease because they're a victim of violence. We have issues regarding credit reporting. And I know at the start of this, you talked about not being able to look at a criminal background search. Alameda County has had, or Oakland has had the rule on the books for quite some time. Unincorporated Alameda County just voted in the inability to look at a criminal background before making a decision. And that's where I was on the news recently. I landed on the belief that, you know, this information is germane and that it should be something that one would evaluate when making a decision to invite someone into your apartment community. But again, I emphasize, I may have a view of something, but the law is the law. So you've got to be very careful and not put yourself in a position of violating the law. There are attorneys waiting and salivating for you to make a mistake so they can actually build their professional and personal financial wealth through the mistakes that you're making. There are going to be additional rules every year. And all I can tell you is they keep coming. And my job is to at least keep letting people know about these laws, and that if anybody has a particular question about a law, then they simply can email me and I'm happy to respond. Slide number 8. I want to mention that I have a lot of situations where instead of getting involved in litigation, I'm negotiating voluntary move-outs. So in Oakland, if someone's not paying the rent and you write them a letter saying, I can't demand the rent, but you owe it and I'm not waiving it, But I would consider, if you vacate the premises, to waive the rent. You are able to do negotiated buyout agreements. In the real estate industry, they call it cash for keys. But it's not exactly cash for keys, because we're not only giving them money to vacate and give us the keys, we're giving them money to vacate and give up all rights under the tenancy and release you from all claims arising from the tenancy. So it's a little bit more cumbersome and more thorough of a contract. Different jurisdictions have different rules. A Berkeley buyout agreement is different than an Oakland buyout agreement. A San Francisco buyout agreement is different. You need an attorney to do it correctly. Richmond has a different ordinance as well. If you don't follow the ordinance, you can be sued, or your agreement is non-effective. So a tenant could take the money and still sue you, despite you having a statement that the tenant's releasing you from all claims. In San Francisco, there's a 45-day right of rescission. So they sign the agreement, they have 45 days to change their mind. In Berkeley, there's a 30-day period. In Oakland, it's 25 days unless it's agreed to be 15 days less. So I want to emphasize, many of the people in real estate, they are charismatic and wonderful, and they are smart. But you've got to recognize your smart, charismatic personality only gets you so far if you don't know what the rules are. So you may be able to finesse people to get to deals that make sense for you as a real estate investor. You still need an attorney to paper over the agreement so it's code compliant and you do all of the paperwork correctly. And I'm happy to guide people through that process.
I'm so appreciative you like emphasizing this, because you have no idea how many times we get asked about, do you have a template of a cash for key agreement so that we can just send it to our tenants? I'm like, no, we are not, we don't have one. And we always send them to consult with an attorney, because like you said, if you just make one term incorrect, you can be sued afterwards. And
Correct.
so
And then if you as an agent give someone a document that's not enforceable, then your brokerage gets sued when they say, well, I relied on your professional judgment and you were a fiduciary in this matter. There's a lot of people who like free stuff. And the only thing is that it creates liability, and you really do need to police your boundaries. And it's out of respect for people so that you don't get yourself in what I call mission creep, where all of a sudden you're a real estate agent and then you're doing negotiations on buyouts and you're creating your risk. So you need to be disciplined, and it requires you to have a clear communication of where your relationship begins and where it ends. And all I can say is, look, I will do the same thing. If you call me for a template document, I can send you a template lease for a particular jurisdiction, but that's where it basically ends. Drafting of these documents create liability for my office, creates liability for you, and I want to have a forthright, thoughtful time period to handle it so that it doesn't make a mistake, because the mistakes sort of exist for quite some time, and we don't want to have that liability for you. We want to do good work for you. So with that, the last slide is, I want to thank everybody for your attention. I want to thank Helen for inviting me. It's my privilege to be invited. It's my privilege to educate. And, you know, I do a lot of social media. I do a lot of e-blasts. And if you get in touch with me and join my social network, what I try to do is educate people about the new laws that come into effect. And when you have real estate related issues that are outside of my purview of expertise, well, Helen's a person that I can refer you to, and it's my privilege and pleasure to do that. And again, this stuff is tricky and it's only getting more complicated. So you've got to recognize that a component of your real estate portfolio and knowledge has to be a little bit about the law and knowing when you need an attorney or a legal consultant to put you in a position of feeling comfortable about the decisions you're making.
Absolutely. I mean, over the years, I had referred quite a few clients to you as well to consult with you before they make any mistakes. We as real estate brokers, we help you to identify a good investment by doing analysis, but then we are also resources to help you identify the right person to help you. Like we tell our clients, you should hire property managers to manage your properties instead of managing yourself, because there's just so many regulations and laws that even I cannot keep up with. I wouldn't even want to compete with, all that knowledge from you. So a lot of times do these kind of webinars. I can say, here you can watch what Daniel has said about the eviction moratorium or all these different laws in the rental market. So I can't thank you enough for agreeing to come on here and speak to our audience. And if you guys have any questions, feel free to contact Daniel. Hopefully you guys had jot down his contact information. So thank you so much everyone for attending. And I hope that you guys will have a safe investment in 2023. Thank you. Bye.